Hello. Welcome, everyone. Thank you for joining us. Today's webinar is presented by the Florence Belsky Charitable Foundation and is titled AI's Impact on Copyright Law. This is the second in our AI series. And we have two wonderful experts here to join us. Marc Ostrow. Marc is a senior counsel at Romano Law PLLC, specializing in intellectual property and entertainment law, particularly in the music industry. He teaches music law at Cardozo Law School and is an alumnus of the University of Pennsylvania and the University of Chicago Law School, and is recognized for his contributions to industry discussions and literature. Marc is also an active songwriter and composer. Barry Heyman is also joining us. Barry has over 2 decades of experience and is the founder and lead attorney at Heyman Law, focusing on music, entertainment, and IP law. He advises creators and businesses on legal and business matters and coordinates the music and entertainment industry studies program at Five Towns College. His background as a classical pianist and DJ enriches his expertise in representing creative talents. Thank you both for joining us, and thank you all for joining us on LinkedIn Live.
Thank you.
Thanks. Thank you for that great introduction, Rivka. So Barry and I are of course, delighted to be here this afternoon. And we have a few topics that we're planning to cover. And as all of you who are watching the webinar know, that AI has been like the hot topic lately. And there are many issues, both with respect to copyright and other intellectual property issues that are implicated by what we call generative AI. So first, we'd like to start to define our terms and talk about briefly, what do we mean when we're talking about AI in this context? For example, AI has been around for a long time. Barry and I are both musicians, and those of you who use Pro Tools or use synthesizers that sample acoustic instruments or even take pictures with your phone, there's AI involved in that. That's not what we're talking about. Barry, you want to add to this?
Well, sure. I think what you're talking about there is what they call assisted AI, in that, it might correct when you take a photograph with your iPhone, it might correct or make some minimal changes. But with generative AI, it uses pre-existing content to create new content that's maybe never been created before. So creating what they call derivative works using pre-existing content. And the issue, I think, here is that pre-existing work, whether it be visuals, audio, or text, are owned by other authors and companies that own those rights to them.
Well, you raise an interesting point, and you touch on something that we're going to touch on a little bit later in our discussion. There is since one of the companies involved is OpenAI, there's an open issue that's being litigated in some of these cases as to whether the outputs do constitute derivative works. Obviously, the defendants in these cases, which we'll discuss briefly, have differing views from the plaintiffs in those cases. So as Barry said, we're talking about generative AI and the kind of programs like OpenAI and Stability AI and a few of these other applications where you put in prompts, and based upon vast amounts of data and pre-existing works, many, if not most of which are protected by copyright, it generates a new work. And so there are questions about both the ingestion of data and information for the AI applications to do its thing and work its magic. And then there are also questions about what kind of outputs are generated by the AI applications and whether they violate any legal rights, copyright being chief among them.
Yeah.
So
Do you
go
think
ahead,
we
Barry.
should start with like what copyright is and what rights you get from copyright? And
yeah, I think a little copyright 101 primer might help for some of the people who are watching us. Copyright is one of the rights that is specifically named in the Constitution. For those of you who are nerds about this thing, it's Article 1, Section 8, Clause 8, which we copyright lawyers refer to as the Copyright Clause, patent lawyers refer to as the Patent Clause, and it is the constitutional provision that authorizes Congress to create copyright laws. Our current copyright law is the Copyright Act of 1976, which has been in effect since 1978. And with respect to copyright, and I was just about to turn it back to you, Barry, under copyright, a creator of a work gets certain enumerated rights, which we refer to as the bundle of rights. And Barry, please explain what we mean when a work is protected by copyright as opposed to registration, and what you get when you have a copyright in terms of the bundle of rights.
Yeah, sure. So I think it's important to discuss, what a copyright is in terms of the requirements to obtain a copyright. And it basically is an original work of authorship fixed in a tangible form. And how I think about it is like three elements. It needs to have some originality. It needs to have authorship, and that authorship is has been limited to human authorship. And I think that's the area where AI and copyright kind of butt heads. And the third one, it has to be put in a tangible form in some fixed medium. So basically, if you have an idea for a song in your head, original melody and lyrics, but you haven't put it in writing, whether it be recorded in some format, then that would be the third requirement that you'd be missing. So we'll touch upon, I think, the real issue here is that authorship component. But in terms of if you do have a copyright, you do have these exclusive rights to do certain things and to prevent others from using your copyright in certain ways. And the exclusive rights you would obtain would be the right to copy, the right to reproduce, the right to then distribute that original work, the right to, as I mentioned earlier, to make derivative versions of that work. So not exactly the same, but for example, if you wrote a book and you want to make it into a movie, for example, that would be considered derivative work. The right to publicly display that work, let's say on a computer or a billboard, the right to, in certain instances, publicly perform that work as well. And so they call that the bundle of rights that a copyright owner obtains when they have their copyright. But another aspect of it is that there are limitations on those rights. There are either exceptions or defenses to using copyrights. One of the big defenses that, again, AI, I believe in copyright, hits upon is what they call fair use, which we'll discuss. And so we have fair use. And then another aspect of copyright is that, as Mark mentioned, there's a limited right for duration that's built into the Constitution. So after a certain period of time, what would otherwise be in what they call copyright falls into public domain and is therefore not protected anymore. So I think, we have to consider, these exclusive rights. We have to deal with fair use, sometimes public domain, if it's not in copyright, things along those lines.
So I want to just amplify a little bit what Barry said. So with respect to the originality requirement, it's a very low bar, but it is there. It just has to be, a modicum of new expression. The leading case in this was the Feist Supreme Court decision that said that the phone book wasn't copyrightable because putting something merely in alphabetical order didn't meet that threshold, but it's a really low threshold. And in terms of things being fixed in a tangible medium, what I tell my students is, as soon as you put your pen down or you hit save or you hit print or you hit record, it's fixed in a tangible medium. So all that's good. And Barry did a really good job of explaining what the bundle of rights are, and whether, and some of these rights, as we'll discuss, are implicated in the use of generative AI. But the first thing that I want to go into a little bit more depth, and Barry, you can chime in freely at will, is the authorship element.
Right.
As Barry had said, under current Copyright Office guidelines and current jurisprudence based on interpretation of what the Constitution requires, is the author of a work that is eligible for copyright protection must be human. Some of you who are watching may remember from a few years ago the famous monkey selfie case. And that, for a brief reminder, that was when the monkey had taken a photographer's picture and actually snapped the photo, and it was a brilliant selfie, and the monkey had a fabulous smile, and the photographer tried to register it for copyright, and it was denied because the creator of the work, the author of the work, was not human. So let's fast forward to some cases from last year and this year. There is someone by the name of Stephen Thaler who has created an AI application for visual art, and he deliberately tried to make a test case and state on the and file attempt to file a copyright registration for a work that was totally generated by AI. And he could have said that, he was the author. For example, the leading case that a lot of the current jurisprudence on authorship traces back to is a 19th century Supreme Court case dealing with a very famous photograph of Oscar Wilde. And the question was the technology at that time, the use of a relatively new medium of photography, could you get a copyright in that photograph? And the Supreme Court basically said yes, but we could spend another hour debating the contours of that case and whether every photograph is subject to copyright. Right now, pretty much it is, but the author still has to be human, and Thaler was denied registration of his AI work because he was honest and said the application generated the work. No human authorship. Copyright Office said no. He sued, and so far he's lost. There was another.
So basically, just kind of circling back to copyright and the elements, it's original, right? It was a minimal bar. It was actually a very elaborate piece of digital art.
It was actually quite pretty.
Yeah. So you have that. You have tangible form. So again, I think the focus of AI and copyright and where they've got heads is that authorship, and whether or not Thaler created the work or instructed the program to create the work. And so that was the issue, the human element, the authorship missing, similar to this the monkey pushing the button on the camera as opposed to the photographer. What's that?
Yeah, pushing the shutter on the camera. So then another copyright registration case that got a bunch of press was the Zarya of the Dawn registration. And that was a graphic novel where the text was totally created by the human author, but the images were generated by an AI application. And it was stated on the registration that it was that the illustrations were totally AI generated. And this went through a couple of iterations. Initially, the Copyright Office issued a registration, and then the quote unquote author, certainly the author of the text, posted on social media saying, "Hey, I got this copyright registration for AI," which prompted the Copyright Office to actually issue open up the registration again and say, "Hey, let's look at this and please provide additional information." And ultimately, what was decided was that the text, which was written by a human being, that was granted copyright registration, but the Copyright Office denied registration for the AI generated work. And things are a little bit confusing. And in March of this year, the Copyright Office issued some fairly lengthy guidelines, which you can get on copyright.gov, and right on the home page, there's something to click on about AI. And basically, it reiterated what Barry and I have been discussing, that some element of human contribution has to be involved. Again, it's an open question, frankly, how much human involvement has to be involved, but there has to be some. So you can't, as we sit here today, have something that is totally AI generated with no human involvement other than giving the instructions, AI, do your thing. And any work that is created that way is not eligible for copyright protection as of November 2nd, 2023.
Right. So we have some other cases as well that came about this year. We were talking a little bit earlier about this, I guess the newer cases are Silverman case and the Authors Guild.
Well, we've discussed, okay, there's the authorship question of AI. And just before we leave that and go to the cases, one point that I want to make, and I made this point on another panel that I was on recently, because AI is a very hot topic, is ultimately the only reason why the AI authorship question is that important is because the companies want to be able to own the AI and be able to derive the economic benefit from it. And the way our copyright system works is that copyright initially belongs, or in the legal terminology, vests in the author of the work. So if there's no author, there's no ownership. So ultimately, the companies that are using AI are going to figure out how to own this thing, whether it's through copyright or some new right that's created or whatever. But ultimately, the authorship issue, in my view, really is all about ultimately being able to own and make and derive economic benefit from the AI generated material.
Mm-hmm. Right. So basically, you're saying that the AI companies, understanding that they're missing the component of authorship, will still seek to own it in some fashion.
In some way, shape, or form. Right now, I'm sure they can do it by contract, but there isn't a statutory provision like the Copyright Act that says, this is a work of authorship and the quote unquote author owns it. Interestingly enough, one of the things that was said, because there is a way, even under our current copyright system, where the author doesn't have to be human. And that is if a work is a work for hire. So, for example, if I am the Disney Corporation, for example, and Barry is either a screenwriter or an illustrator or what have you, and he is an employee of Disney, under the Copyright Act, the work that he does, even though he's the creator, Disney Corporation, not a human being, but the Disney Corporation is deemed to be the author of the work. So they actually tried that argument in the Thaler case in the Copyright.
In the Thaler case, that's right.
And the copyright office said, "Nice try, guys."
Yeah. But interestingly, they did it in reverse, I guess, because they're saying that the computer generated it and then it was done for Thaler, or
so it's like so at least in my hypothetical, Barry, you're still a human being, so you can actually agree and assign on a work for hire basis your output. How does the AI be an employee for hire? I guess
right.
That's what the Copyright Office was saying. So why don't we turn to a couple of the current cases, and then we can even talk about some recent current events before we open things up for questions. There have been a slew of cases dealing with AI that have similar allegations, and with respect to the large language, I forget exactly what the term is. There are two aspects that we kind of alluded to earlier. There's the ingestion of all the material, a lot of which is going to be copyrighted. And so there are questions about the legality of that. And then there's the individual outputs from the application, having digested and absorbed all that material and did what it did to produce a new work, although it's AI generated. So there was a case, the Stability AI case against Stability AI filed by Getty Images. So that was a visual works case. Then there was the Authors Guild case, which a bunch of book authors sued the various AI applications. And then, as Barry alluded to, there's the Sarah Silverman case, which, again, several authors have sued over the use of their works in both ingesting and training the AI application and in some of the outputs. And finally, just within the last 2 weeks, the music industry has finally gotten involved in one of these lawsuits, but not in the way that many of you in the audience may be thinking. First of all, it was the music publishers, not the record labels, who filed suit. And it wasn't about the music per se, it was about the lyrics to the songs. So again, just like the Authors Guild case and the Sarah Silverman case, this is basically a literary works case that the music publishers have filed. So
you
Barry,
kind of go back and talk about the ingestion process.
Yeah, I was just going to say, Barry, why don't you talk a little bit about some of the issues raised by the ingestion of the works?
Yeah, so going back to those exclusive rights of copyright law, you have, as the author and owner of the work, the exclusive right to reproduce the works. And so by these companies that you mentioned earlier, the large language models, right, the LLMs, they ingest all this third-party material owned by these, whether it be authors, writers, or in this Concord Music Publishing and all the other publishers' cases, they or plaintiffs, they bought those rights from the authors, and so they are the owners of these copyrights. And what they're basically saying is, in order for this generative AI machine to spit out new information or content, you're training them on all our content. And so you're ingesting and making unlawful reproductions of our content without our permission. You didn't, you haven't sought to a license to do that. And basically, they've done it by, I guess, public scraping the internet and all these different websites. And so these are works that are in copyright as a not public domain works, so they're not very old. And basically that's the ingestion component, and potentially, I would think, and then I guess on the outside, what, if you're a
Well,
user of these,
let's put
yeah,
a pin in the output part first. So
okay,
you've explained really well what the ingestion process is and what the plaintiffs in these cases are saying, that there's a bundle of Section 106 bundle of rights, the reproduction and distribution rights are being violated. What are the defendants saying? Because clearly they're not rolling over and saying, "Oh, you got us."
hmm right. Well, I would think that they would be saying that. Well, as far as that aspect of it, they're probably saying that they are indexing the material and that no one is really viewing it or have access to it except for them. I would think that they might argue it would be fair use, would be something that an earlier case from some years ago was that where Google took vast amounts of copyrighted,
Several
what's
million
that?
books.
Millions of books, and basically ingested it into their system, and that was determined to be lawful because of how it was, being used, and basically the general public wouldn't have access to read all those millions of books, or any one in particular, actually. And so therefore, one could argue that this is similar to that, in that they're ingesting it, just like Google had millions of third-party content. I think potentially the issue might revolve more around what the users of, let's say, Google versus these other companies that are being sued offer, any person utilizing these programs.
Yeah. Before we go on to the user aspect and the output aspect,
Yeah.
I want to amplify a little bit what Barry said. And again, sometimes these panels are more entertaining when you have people vastly disagreeing. This is kind of the mutual admiration society. I've agreed with everything that Barry said. I just want to amplify on a few things and talk a little bit more about fair use. One of the things that the Google Books case that Barry was talking about said is that the output, as Barry said, it wasn't the actual books that any user of Google could find. What they found was snippets that basically were brief summaries, and Google argued under applicable jurisprudence that the use was quote unquote transformative, that it wasn't a substitute for the actual books. In fact, not only did it not adversely affect the market for the books, which is one of the factors under fair use, but it could actually enhance the market because it enables users to actually find the book. And if they want the book, they can click on a link and go buy the book. So it was basically used for a different purpose other than the original purpose of making books available that people read. As Barry said, the actual books and the millions of books that were ingested, you couldn't use Google to actually read those copyrighted books. You'd only get a brief summary to see if you wanted to delve further and perhaps buy the book. So that is an important point to make about the ingestion process, because there, at least, and again, my personal view is I think even the Google Books decision went too far. And given my background, which anybody who's watching can go Google me and look that I've worked for music publishers and creators, I personally think that all this stuff should be licensed somehow. But here we are. It was deemed to be a fair use. And so the AI companies are saying, hey, this is just like Google Books. We're ingesting this stuff. Nobody's going to be able to access any of the copyrighted material that was ingested. And we're using it for a different purpose. In other words, to create new works. So then we get to the output part. And again, all of these cases are currently being litigated. Nobody knows, as we sit here today, whether the AI company's fair use arguments will fly.
Right.
So let's talk.
If you'd like, I can talk about the output side of things.
Yeah, take it away on the output.
So, so on the output side with these AI companies, is that the plaintiffs in these cases, the authors, the publishers, are arguing not only are you ingesting our content and reproducing it without our consent or license, but you're also then distributing it potentially to the public without our consent, and that's another exclusive right. So you have right to reproduce, right to distribute, and further, you're potentially making derivative works of ours. So if I say, hey, if I put in a prompt to one of these AI programs, write me a lyrics to a Bob Dylan song mashed up with a Drake song, it would potentially be combining to create something that was both Bob Dylan lyrics and Drake lyrics. So now you're not only just potentially spitting out lyrics that are exactly the same, because you could also put in the prompts, by the way, what are the tell me the lyrics to a particular Katy Perry song, which I believe is in that Concord complaint, and it just basically sends out prints displays all the same exact lyrics. So you also have the right, as I just mentioned there, the exclusive right to display. So basically the publishers and authors are saying basically you're not only reproducing, you're distributing, you're potentially making derivative works, you're publicly displaying our works as well, and these are our exclusive rights. And I think when we were talking about this Google case, and if we were going to potentially distinguish Google from and what users can access in terms of maybe a summary of a book as opposed to the text of the full book, and in this case you potentially get the lyrics to the whole songs, and the question is whether it's transformative, because I'm sure Concord and Universal are making money from licensing Katy Perry lyrics in full to third parties. And if there's a company here,
as you know, Barry, there are legitimate licensed lyric sites,
right?
And the publishers do make money off of that, and which means the songwriters make money off of it,
right? So I think that's really the crux of potentially where the courts might come down and finding a distinction here between the Google case and these current cases. What do you think?
There on the output side, there are also a few other issues for example, and that's where some of the more recent cases come in. For example, let's go sticking with literary works. So, for example, if I were to say, write me a sequel to Stephen King's It, certainly a sequel would be a derivative work of a specific work, and that's a violation of one of the bundle of rights that a copyright owner has. But if I put in the prompt, write me a new work in the style of Stephen King, unless copyright, one thing that I don't think we stressed enough at the beginning is that copyright protects only specific expression. It doesn't protect ideas per se. It only protects specific expression. So if I put in a prompt, write me a novel in the style of Stephen King, unless it spits out sentences that were actually written by Stephen King, that wouldn't be a copyright violation. But there are other IP laws that I alluded to at the very beginning of our discussion that may be implicated here. You can't copyright a style, just like in music, you can't copyright a groove or a feel, despite the outcome of the blurred lines case. The holding of the blurred lines case is that you can't copyright a groove or a style or a feel, and certainly that was reiterated in the Ed Sheeran verdict. But with respect to an author's, write me something in the style of Stephen King, there could be a claim of a state-based claim called unfair competition, for example, that says, hey, I'm Stephen King, or I'm Stephen King's publisher. We have the rights to books by Stephen King, and you're taking away an economic opportunity by claiming that this fake Stephen King. So that's kind of the basis of the claim there. Another aspect is something that just came up within the last day or two. There's a Scarlett Johansson claim now that her image was used without her authorization through AI to endorse a particular product. And again, unless she had copyrighted the actual words that the AI Scarlett Johansson was saying, that's not a copyright claim per se. That would be a right of publicity claim, potentially, and some of those claims go back to the 1980s with at least two very well-known singers. You want to talk about those cases, Barry?
Yeah. So, well, the one case that I think you're referring to is the Bette Midler case.
Yep.
And where basically, I believe Ford sought her permission to use. They wanted her to advertise their cars, and so she said no. And then they hired someone to sound just like her, and they basically put it out commercially, and she sued based on the unauthorized use of her voice, or her what they call likeness, and she won that case. And so using potentially, in this case, I'm not sure the Scarlett Johansson, if they used her voice or her, but her voice, your image, basically all these things, your name even. They weren't in that Ford commercial saying it was Bette Midler, but you would think it would be her based on her distinctive voice, just like any other modern day celebrity. And it comes up a bit when we talk about, like, let's say the Drake Weekend mashup, when you're using unauthorized voices. And there was another case you were referencing earlier.
From the same era as the Bette Midler case, like a year or two later, they didn't learn their lesson, and they ripped off Tom Waits, who has been notorious for always saying no to licensing his music for commercials. So they were asking for trouble with Tom Waits. So Barry mentioned the fake Drake case, the quote unquote collaboration between Drake and The Weeknd, and that was taken off the streaming services. But interestingly enough, and I think Barry, you and I were talking about this last week when we were preparing for what we were going to say today, that how they got it taken down was not based upon the AI, because again, it wasn't a copyright violation. There were potential rights of publicity saying that, a sound-alike of Drake, and The Weeknd, even though it was not generated by a human imitating their voice, but it certainly sounded like them, and it was claimed to be initially a collaboration between the two of them. But the creator of that work actually used an unlicensed sample. And,
right.
And that's how Universal got it taken down. We're going a little bit far afield here for those of you who are familiar with DMCA takedown notices. DMCA takedown notices apply to copyright violations. So there had to be a copyright violation to get the fake collaboration taken down, and that was the hook that they had. So you can see in some of the graphic works AI, you can say, create something in the style of a famous artist, even a living artist, a famous comic book illustrator, for example. Graphic artists and illustrators and painters have their own distinctive style, just as writers do. And again, those are the kind of state-based unfair competition, right of publicity claims that arise from some of these AI cases.
So we're going to talk now about how do we get over these hurdles with lawsuits, or do the industries come to terms? Do they sort out their differences? What do you think? Do you think we set it up enough? I know we only have a little bit of time left.
We do have a little bit of time left before we open it up to questions, and of course Barry and I are happy to continue talking if those in the audience don't throw questions at us. But there are a couple of possible outcomes. First of all of these cases are being litigated right now, and if the courts go the defendant's way and they decide, like the Google Books case, at least the ingestion is fair use, well, then there's nothing to be licensed if it's deemed to be fair use. On the output side, again, it depends upon the particular output and what the claims are. I might add that in the Sarah Silverman case, they raised some of these non-copyright claims, and they're all state-based claims, and so right of publicity, unfair competition, and the like, they all are based on state law. Some states have statutes dealing with them. Others are based on case law, or what we call common law. But the upshot is that these rights vary from state to state. For example, in some states, the right of publicity terminates on the particular celebrity's death. In other states, it goes on for a period of time, varying from state to state after the person dies. Sometimes you have to be particularly famous or something to be able to assert post-mortem rights and right of publicity. I think the Michigan statute has wording to that effect. But in the Sarah Silverman case, the defendants have filed a motion to dismiss all of the non-copyright claims, all of these state-based claims that Barry and I have been talking about for the last several minutes, the right of publicity and especially unfair competition, saying that they're preempted by the copyright claims, and federal law trumps state law, and the Copyright Act has a particular statute provision dealing with preemption, saying if you're asserting rights that are basically the same rights, the same claim as the copyright claim, then it's preempted. It has to be something different. So name, image, and likeness, that wouldn't be preempted, but an unfair competition claim where the only unfair competition is you're infringing my work, that's basically a restatement of a copyright claim. So now let's assume that the plaintiffs win and the ingestion isn't fair use, and AI isn't going to go away because it is a very valuable technology, and like any technology, it has certain dangers and could be abused, but it's a pretty awesome tool. What are some of the ways that the copyright owners, if they win, can be compensated? So you want to start us off, Barry?
Yeah, sure. Well, one, they could just negotiate business terms, and those business terms, I mean, the standard in entertainment and with copyrights is that if a third party wants to use a particular work or catalog of, let's say, a publisher or studio, they would potentially negotiate some monetary license arrangement, typically monetary based. They don't have to agree to it. But these companies are partnering with other AI companies. And so they are seemingly the major companies like Universal, I believe, and is it YouTube came to some type of partnership arrangement, and I believe the Images is partnering with an AI company, and so the idea is that they come to the table and they share in some kind of revenue share, typically licensing the content on some kind of terms.
Yeah,
that's one aspect of how things can be resolved.
Yeah, Barry and I, as music lawyers, we're used to dealing with some of these issues, and one way that he said is there can be private agreements, and for a lot of streaming, certainly for interactive streaming, the major record labels have all done deals with Spotify and other services, and so there are direct contracts involved. Another aspect, if it's not on-demand streaming, but non-interactive streaming, there's a particular statute that the streaming services could avail themselves of, and they can get a statutory license. So another way of dealing with this, and those of us who are watching have probably seen reports in the press that in some instances people are clamoring for legislation. Let's have some sort of government mandated license scheme. And that can take various flavors. And Barry and I were just talking a little earlier about how certain rights in music land are licensed, and sometimes there's a statutory backdrop that's kind of like a default position that is rarely used, but is available, and everybody kind of contracts around it. You want to talk about briefly how mechanical licensing works, Barry, and whether that might be an analog to what could happen here?
Yeah. So, while these issues are not specific only to music copyrights, but in the music industry, they're, to kind of counter these major companies having a monopoly on these rights and granting or issuing licenses to third parties, there's laws that were put in place to basically have like allow third parties to use content without actually having to get permission from them or directly. And so there's compulsory licensing that requires these companies to issue licenses. So because the underpinning of this whole constitutional copyright law is to promote arts and sciences, and if companies basically hold on to their copyrights and not issue licenses, it would kind of run counter to that. So it's a bit of a balance there to require content owners basically that have these exclusive rights to basically have an exception here that says, well, you have these exclusive rights, but actually you have to issue licenses. So if they don't negotiate privately these direct deals, another one would be potentially to mandate that they do so. And that's basically what has been happening with publishers that own melody and lyrics to songs, that any party can basically put out their rendition of or cover songs of these third-party written songs and just get a license, what they call a mechanical license. And that was further, I guess, instead of on a song-by-song basis, now when you're talking about digital music licensing, now they even have concepts like blanket licensing. So it's not even a compulsory, case-by-case basis, but maybe it's, a whole catalog or everything that's out there. And so I know Mark has a background in blanket licensing, and that MLC is about blanket licensing. And I don't know if you want to touch on that aspect.
To amplify on what Barry said, with what's called the mechanical license, and the term goes back to the first mechanical license dealt with piano rolls, but it applies to audio only recordings. And basically, once a song is released on a commercial recording, anybody can do a cover recording as long as they the owners of the songs can't say no as long as the quote unquote statutory rate for the license is paid. There are problems with government mandated licenses. For example, the rate setting proceeding before the Copyright Royalty Board of the Copyright Office for the mechanical license for these cover recordings and these new blanket licenses that Barry was alluding to for the streaming services, the period for the license period for 2017 through 2022 was finally settled a few months ago in 2023. And these proceedings went on for several years and several millions of dollars to essentially litigate what these statutory rates are going to be. So for 5 years, people didn't know exactly what the rate was going to be. That's not a way to run a business. So statutory licensing isn't a panacea necessarily. One thing that's a quasi-compulsory license is the way that public performing rights in songs are licensed, which is what ASCAP and BMI do. And it's a quasi-compulsory license because there isn't a specific statute that says thou shalt issue a public performing license and the Copyright Royalty Board is going to set the fee. But both ASCAP and BMI have been operating under consent decrees since the 1930s. And anyone who wants a license can just send a letter saying, I want a license. And then there's a rate setting proceeding if they can't agree to a license. So it's kind of a compulsory license. And the way ASCAP and BMI license and the way mechanicals for the streaming services are licensed, as Barry alluded to, is what's called a blanket license. So, and that refers to, I refer to it as the all-you-can-eat smorgasbord. So let's say that Barry is a radio station. And I used to work at BMI. So let's say Barry's radio station wants to get a BMI license. So for a set annual fee, Barry gets issued what's called a blanket license, which means he can perform on his radio station any or all, in whole or in part, and as many times as he wants, the songs in my BMI catalog, which is millions of works by thousands of music publishers. And so he doesn't have to worry about individual licenses. So what's the potential problem with that? On the other end, BMI and ASCAP have to figure out, once I get all the money in from all these radio stations, TV stations, nightclubs, arenas, anywhere where music is publicly performed, how do I distribute that to the songwriters and music publishers? And it's a very, very complicated process, but it's been working more or less with a few litigations here and there for many, many decades. So blanket licensing may be a potential solution here, but that depends upon how the litigations turn out, if there is anything to be licensed.
Right. And so I know we have to wrap up soon here, but I guess in terms of the spectrum here, we have, if there's, like you just said, if there's nothing to be licensed because it's fair use, then the AI companies can do what they want with this content. Or they might have to alter how they use the content. Maybe like Google Books, they put restrictions on, if I say, tell me the lyrics of, Katy Perry song, that it won't spit it out. It won't, give me that information. But maybe it'll create something using Katy Perry lyrics mixed with Drake lyrics, mixed with Bob Dylan, that's never been created. And it would be, not even potentially a derivative work. It would be so transformative in nature, so to speak, that it would be a fair use. So we have potentially fair use. We have companies like AI companies modifying their how the actual programs work. Or then you have also this compulsory licensing, blanket licensing with all these companies, or private negotiations, direct negotiations. And the only last thing I see are utilizing public domain content where there would be no permissions required.
Right, Dickens and Beethoven are still good.
What's that?
Dickens
Oh,
and Beethoven
Beethoven.
are still good.
Yeah, right. And so there's that aspect, and or people could join and and then enter into, I guess, yeah, that would be the direct licensing. So I think that's pretty much the spectrum of how they most likely might work. How things will have to work out.
Barry, do you have any final thoughts on where all these litigations and the Copyright Office guidance and everything else? Because it's still, everything's being litigated, is still kind of up in the air. Any thoughts on where you think it's going to shake out?
I think it's sometimes easy to think about it, very broadly, or generally speaking, it's lawful or it's not lawful. It's fair use or it's not fair use. And I think to look at it, maybe unfortunately, or you have to really kind of, all these cases have different aspects to them, whether there's copyrightability to begin with. Some cases are about how these companies are utilizing the content, if it's to determine if there might be fair use or not, and so I don't think there's an overall generative AI, and the use of it is automatically illegal or automatically fair use. I think you really have to kind of say, well, what material are you using? How are you using it? That sort of thing. And that's my thoughts at this point on it. But I don't know that from the cases that we've been talking about I know these companies, their position right now, I think more formally, as of yesterday or today, is that it's fair use. And so I based on, especially that Google case, and maybe there's other ones out there, but I don't see them being aligned with how Google and the Google Books case is the same as these cases, especially in the output side.
Yeah, I think you're right that we're not going to see a one size fits all kind of outcome here. I do think that the Google Books case is somewhat distinguishable on the output side, because I think there is more, at least with some of the outputs, as we've been discussing, write a novel in the style of Stephen King, where you are actually using the application for the same purpose of the underlying work, or in the words of Justice Story, as it was incorporated into the statute, it's a substitute for the copyrighted work. So I think there is some distinction with respect to at least a potential big swath of the outputs that would be distinguishable from the Google Books case. But bottom line, as we come to the top of the hour, it's still all being litigated. There's no legislation that's been proposed yet. So we'll just have to wait and see.
Yeah, maybe we could do a part 2 and see where we're at in a few months.
Yep.
Thank you so much for being here. This was so informative. This was a great episode to have in this series on AI, and a great resource for our advisors. Thank you so much for sharing your expertise, and have a great afternoon, everyone.
Thank you.
Thank you.